Doctor, in preparation for coming to today's questioning, today's deposition, did you review any records? The defense lawyer jumps up and yells out, objection! I direct the doctor not to answer that question. First, can the defense attorney object to that question? Second, why would I even ask such a question in a medical malpractice case during a pretrial deposition? You want to know the answer and why it's important? Come join me on this walk along the beach as I share with you the precise answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, let's say it's a medical malpractice case. You sued your doctor claiming that he was careless, causing you significant harm and injury. And now, during the course of your lawsuit, I will have an opportunity to question the doctor whom you have sued. That's known as a pretrial deposition. It's really a question and answer session under oath, and it usually takes place in the attorney's office. Nowadays, it takes place on a Zoom call, and we have a court stenographer on the Zoom call to record all of my questions and all of the doctor's answers. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial in court in front of a jury. So now, one of the questions I will ask him during the course of his questioning is, Doctor, in preparation for today's questioning, did you review any records? And the answer will always be, yes, I reviewed the patient's records. Okay? Did you review any other records? And in 99.9% of the time, the doctor will say, no, I did not review any other records. Doctor, do you have any notes, handwritten notes about this patient that's not contained within your chart? And most of the time, the doctor will say, no, I don't. If the doctor says yes, well, guess what? I'm entitled to know what notes he referred to help him refresh his memory. I'm entitled to know exactly what it was that he used to prepare for questioning today. So now, here's an interesting scenario. Let's say I asked the doctor if he reviewed any particular records. Now, there's no problem with that question. It's a totally appropriate question. And the doctor says, yes, I reviewed the patient's records. And now I say, doctor, did you review my client's pretrial testimony that she gave last month? Did you review her transcript? And he says, no, I didn't. Okay. Doctor, did you review any medical literature in order to prepare yourself for today's questioning? Occasionally, a doctor will turn around and say, yes, I did. Now, here's where it gets interesting. The moment the doctor acknowledges that he reviewed some medical literature to prepare for the questioning, I can now go ahead and ask him questions about what he reviewed. Why is it that the defense attorney would now go ahead and yell out, objection? I direct the doctor not to answer that question. I'll tell you why. It's because she doesn't want me to know exactly what the doctor reviewed. Is that appropriate? Absolutely not. And why is it not appropriate? Because I'm entitled to know exactly what it is that the doctor reviewed in preparation for today's questioning. I am entitled to not only know about it, but I'm entitled to see every single document, every single thing that he looked at to prepare himself for today's deposition. So what does that mean? What's the implication there? If the doctor looked at any medical literature or any medical textbooks, I'm entitled to ask the doctor exactly what it was that he looked at. What research did he do in order to prepare himself for today's questioning? And then I'm entitled to know whether he has that literature or those textbooks with him. If he has, I am entitled to see exactly what it was that he reviewed. Doctor, what literature did you review? What was the title of the article that you read? What was the title of the book? What was the chapter that you reviewed in order to prepare for this deposition? There have been only a handful of instances where doctor number one has actually admitted that they did some type of medical research in preparation or anticipation for this particular questioning. And then there have been even less, only a few instances where I have now been able to get the doctor to admit that he actually had that medical research with him in his briefcase. And you know what I said after I learned that? I said, doctor, I'd like you to take those articles out and show them to me. You should have seen the attorney's look. She had that deer in the headlights look, and she didn't know what to do because she realized that she could no longer object to that particular question. In that instance, I can now pull those articles out, I can ask him for it, and now I can take the time to review it and go through each and every one of those articles and then ask him questions about everything that he read. I might even be able to ask him questions about whether he agreed with certain portions of what's contained in those articles. Now here's something else that you may not know. Unless a doctor actually admits that a particular piece of literature, medical literature or a textbook or portion of a textbook is authoritative, I usually will not be able to get the doctor to answer questions about what's contained in that article. It says here that if a patient complains of A, B, and C, the standard of care requires that you do X, Y, and Z. I would love to turn around and ask the doctor, "Doctor, do you agree with that? Have you published anything in this field of medicine? Do you agree with that? Do you disagree with that? Tell me why." But now let's get back to the literature that the doctor has admitted reviewing and now brought with him, and now I start to review it. In all likelihood, I would argue that I have the ability and the opportunity to go ahead and ask him questions about what he read and his opinions about what he read in anticipation of today's deposition. So why do I share this with you? Well, I share it with you because my wife is actually down there on the beach picking some great seashells. And I had a few moments to share this great information that I thought would be eye-opening to help you truly understand how these types of lawsuits work in New York. You know, I recognize that you probably are watching this video not for the scenery, but rather because you have questions of your own. Well, if your matter happened in New York, but you still have questions and have not yet started a lawsuit, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.